The manager said facts are a stubborn thing. Let me give you some facts. It's from the transcripts. Ambassador Sondland actually testified unequivocally that the president did not tie aid to investigations. Instead, that he acknowledged any leak he had suggested was based entirely on his own speculation, unconnected to any conversation with the president. Here's the question. What about the aid? Ambassador Volker says that they were tied, that the aid was not tied. Answer. I didn't say that they were conclusively tied either. I said I was presuming it. Question. Okay. And so the president never told you they were tied. Answer. That is correct. Question. So your testimony and Ambassador Volker's testimony is consistent, and the president did not tie investigations, aid to investigations. Answer. That is correct. Ambassador Sondland also testified that he asked President Trump directly about these issues, and the president explicitly told them that he did not want anything from Ukraine. I want nothing. I want nothing. I want no quid pro quo. Tell Zelensky to do the right thing. Similar comments were made to Senator Johnson. Those are the facts. Stubborn, but that's the facts. No one is above the law. Here's the law. As every member of Congress knows, undoubtedly aware, separate from even state secret privileges is the presidential communication executive privilege to communications and performance of a president's responsibilities. The presidential communication privilege has constitutional origins. Courts have recognized a great public interest in preserving the confidentiality of conversations that take place in the president's performance of his official duties, because such confidentiality is needed to protect the effectiveness of the executive decision-making process. In Ray Seal cases, that was decided in the District of Columbia Court of Appeals. The Supreme Court found such a privilege necessary to guarantee the candor of presidential advisors and to provide a president and those who assist him with freedom to explore alternatives in the process of ultimately shaping policies and making decisions, and to do so in a way many would be unwilling to express except in private. For these reasons, presidential conversations are presumptively privileged. There's something else about this privilege. Communications made by presidential advisors, again, quoting courts. And by the way, lawyer lawsuits? We're talking about the impeachment of a president of the United States, duly elected. And the managers are complaining about lawyer lawsuits? The Constitution allows lawyer lawsuits. It's disrespecting the Constitution of the United States to even say that in this chamber. Lawyer lawsuits. Here's the law. Communications made by presidential advisors in the course of preparing advice for the president come under the presidential communications privilege, even when these communications are not made directly to the president. Even when they're not made directly to the president, advisor to advisor. Given the need to provide sufficient elbow room for advisors to obtain information from all knowledgeable sources, the privilege must apply both to communications which these advisors solicit and receive from others, as well as those they authorize themselves. The privilege must also extend to communications authored or received in response to solicitations by members of a presidential advisor's staff, since in many instances, advisors must rely on their staffs to investigate an issue and formulate advice given to the president. Lawsuits. The Constitution. A dangerous moment for America when an impeachment of a president of the United States is being rushed through because of lawyer lawsuits. The Constitution allows it if necessary. The Constitution demands it if necessary. Thank you, Mr. Chief Justice.